We are going to talk today about civil rights. And we talked about civil liberties last week, or earlier this week, actually, I should say. And civil rights and civil liberties differentiate themselves in two ways. One, civil liberties, as we said, are those rights that are defined specifically under the Constitution and protected by the law. Civil rights, on the other hand, refers to the right of every person to equal protection under the laws and equal access to society's opportunities and public facilities. Civil rights differentiates itself from the protection under the law to these are things that you just have by being alive and being a person. Now, group membership is an important aspect of civil rights. Race, gender, religion, nationality, age, disability, sexual orientation, sexual identification. All of these things, all these group memberships can in some way limit your ability to be a part of a certain club. If you are of a different race, if you're Asian Pacific Islander, for example, a female, Buddhist from, we'll say Tibet, if you're a younger person around 18, you've got a stutter, you're, you know, I could go down the list and literally just mark off different things that could potentially disqualify you from a certain thing or a certain place uh, because of the way that society works. Um, so anyway, uh, so civil rights issues concern equal status and treatment, equal opportunities for political participation in both voting and running for office. Um, it should ensure uh, that no matter what your race is, no matter what your background is, you should be able to run for public office, and that uh, diversity is a good thing for public office. It brings a different lens, a different form of participation to uh, the actual office and political sphere. Now, equal opportunities in jobs, housing, and other essential aspects of life. Um, People have been discriminated against for jobs, for housing, and whether or not they can use laundromats or just other essential aspects of our lives, things that you don't really think about when you have access to all those things. Like I'm in a wheelchair. There are places that I can't get to because of grandfather clauses in the Americans with Disabilities Act. Uh, I have I can't definitively prove that I've been turned away from jobs, but there are certain jobs that I guarantee you would not take me because of my disability. And I can't say that it hasn't been the case in the past that there's been a job that I'm overqualified for that I haven't gotten. And I'm not playing victim. That's just the way the world worked. Uh, as far as 10 years ago. Uh, but civil rights as a whole should protect you from the bulk of this type of discrimination. Now, different groups require civil rights and equal treatment in various methods, depending largely on whether discriminatory practices are aimed at them are intense, entrenched, and widespread. Intense meaning like, this is something that happens all the time. Entrenched meaning it's happened over a long period of time. And widespread meaning it's community or nationally understood. Again, I go back to disability because this is where I really experience most of my civil rights issues is the grandfather clauses of the Americans with Disabilities Act says that people are exempted from making their businesses accessible to people like me, or making their establishments accessible to people with disabilities at all. You don't have to, as long as they can display that it would be an undue burden for them to actually take on that responsibility. Um, and this has happened in the court several times. Now, the ideal of political equality. The founders of the United States wanted to enjoy political equality, which would allow them to express their views, own property, and participate in a Republican governing system. This obviously is an era in which they took for granted that women need not participate as important decision makers in economic and political affairs, and also at this time, slaves and Native Americans were viewed as less than equal beings and did not deserve the benefits of law or the opportunity to participate in politics. Women, slaves, Native Americans, three groups that were essential groups to the original founding of the country, but were left out of the political process. Uh, there were, and we could apologize for the founders a little bit and say that they were starting to move toward making things equal inside of that realm. But let's be honest, there was never a true effort until long after um, the actual founding of the country to actually try and make these things right. And in some cases, and especially with the Native Americans, we still haven't done nearly enough to ensure that Native Americans have a place inside of our country. There were a lot of things that were done during the founding era that would be, not just controversial, but unacceptable to today. Now, freed slaves faced starting from scratch. They were excluded from employment, housing, and services. Rights protected educational, political, and business opportunities for themselves. President Johnson, and this is Andrew Johnson, allowed the South to reconstruct itself. In essence, Abraham Lincoln was killed before Reconstruction could begin in earnest. And we could only imagine what Reconstruction would have looked like had Lincoln lived to see it. I could also make an argument for President Garfield. If President Garfield had not been assassinated, we might have seen a completely different civil rights era that would have happened 100 years before the actual civil rights era uh, actually took place during the 1960s. But we'll never know because President Johnson essentially took a hands-off approach, and Johnson, being from Tennessee himself, really took a hands-off approach to how the South recovered from the Civil War. As a result of that hands-off approach, black codes emerged and imposed year-long labor contracts, coercive apprenticeship regulations, and criminal penalties for breach of contract. This was essentially a new form of slavery. It was a legal form of slavery that the states decided to pick up in response to, um, that the South essentially picked up in response to the newly freed slaves. Slaves had to go somewhere. They had to work. They had to find places to live and a way to survive. And the only way to do that would be to basically indentured servitude, which had already happened through the colonial days, but now it moved into the newly freed or post antebellum or post Civil War South, and it would lock these people into debt that they couldn't get out of. Uh, you would make you'd spend $1 on food, for example, and make a nickel. So it would take you that amount of time, and that in the meantime, the loan that you took out in the first place was gaining interest, and you'd never actually catch up with the loan. So these people were kept, really in place by these new programs and regulations that were being created across the South, and the federal government did nothing to stop them. Now, radical Republicans, former Confederate states were required to establish new state governments based on the granting of voting rights to both whites and African American males. Union military commanders repealed many elements of the black codes. Um, this is the early part of Reconstruction, by the way. African Americans had voted for and run for office in 1868 and 1870, with 18 being elected to Congress. Both of Mississippi's United States senators and one Georgia congressman, Jefferson Longman Macon, were notable among these men that were elected. Um, Now, the Constitution has been amended, of course, at the end of the Civil War. We talked about these amendments. The 13th Amendment actually abolished slavery. The 14th extended citizenship to African Americans, including equal protection of the law and right to due process under the law for all races. And then the 15th Amendment, the right to vote was extended to black males. All three amendments needed congressional legislation to enforce their provisions. Um, So at the federal level, this is fine. Like we talked about how, when the Constitution is amended, it's only amended at the federal level. It's up to Congress then to draw laws and to make it actually apply to state law by creating laws that are effective only to the states themselves and not just to the federal government, and making them legitimate in that way. Following the election of 1876, Southern state governments gave way to Bourbon Democrats. Um, the Bourbon Democrats are generally, and this is where the hands-off part comes into play. Conditional voter registration. This time was known for redemption. And Bourbon Democrats were called Redeemer Democrats in this way. Uh, Especially North Carolina in 1877, they were conservative Democrats that were essentially redeeming the South from Republican Reconstruction, and also redeeming the South from actually having to deal with the ramifications of the freeing of the slaves, which led to the black codes and the other things that we were talking about before. So conditional voter registration is literacy test, government knowledge test, and intimidation and violence, and also targeted at many poor whites. This was an era where, when voting rights had been expanded to not just landowners but everybody, all of a sudden the political elite in the country um, all of a sudden found their power slipping away a little bit. They didn't want everybody to vote. They wanted people that would vote for them to keep them the money. And this was their answer to doing that. And these government knowledge tests, or the literacy tests especially, they would be written in a manner that even the people giving the test could not pass them. There was like a one test where you had to draw a straight line without lifting your pen and connect a line to a dot on the other side of the paper, but there was a solid black line in between. There was just no way to do it. Uh, there were also like the questions that had no answers. There were just questions that just said things and there was no actual right answer to them at all, or they would just outright fail. Jim Crow laws were then enacted across the South. State and local governments enacted these laws as separate but equal facilities, separated white and colored facilities across the South. Waiting areas, public restrooms, restaurants, drinking fountains, bus stations, uh, anywhere that you could think of that a white person would be, there was also an area for a colored person, except for in some public facilities, they were for whites only, including swimming pools and parks. The law in the South did not protect blacks and whites equally. In the same way that you could say in the modern era, the Me Too movement empowered women to come out against their attackers. In this era, if you were a black person accused of a crime against a white person, or if you were a black person that committed a crime against a white person, you were going to jail, if not being hung or lynched. If you were a white person that committed a crime against a black person, then hardly anything happened ever. You were protected. So in this era, blacks faced not only prison, but also numerous cases of lynch mobs that tortured, murdered, and mutilated the accused. The actual lynching of black men was happening up until the 1950s, maybe even later than that. And you could probably even make a more modern day case in some instances with the way the police brutality has been handled. It's been described as lynch mobs in the streets with the police. In some ways, yes, it does call back to that era of humiliation, of degradation, of just not good, not a good look in the South at all. And it's just something to think about, I guess. But back to the 19, well, probably in the 40s at this point with the Jim Crow laws. What was your Ferguson? Plessy versus Ferguson is an 8-1 decision that the Supreme Court held that there was no violation to the constitutional right of equal protection when states had separate but equal facilities and services for people of different races. John Marshall Harlan, in his dissenting opinion, wrote that our Constitution is colorblind. The common government of all should not present the seeds of race hate to be planted under the sanitation of the law. This was the court's unofficial, or actually not unofficial, but official endorsement of the separate but equal policies. And then de facto segregation. Real estate and mortgage brokers steered to force African Americans into ghettos. School boards segregated schools with discriminatory housing patterns. Employers practiced discrimination in hiring and promotion practices, and police and law enforcement practices up to today. It's been the same throughout the entire time. And you could also make an argument there have been modern cases of real estate and mortgages as well. Not just steering you into ghettos, but the way that you walk into a jewelry store sometimes and you're wearing gym shorts, and the people at the store don't take you seriously because you don't look the part that like you have money. Versus if you come in with a suit and tie and they listen to you, and they charm you and they try to offer you some wine and dine you and try to get you to part with that hard-earned money that you obviously have in your pockets. It's happened to me as well. I mentioned it. School boards were segregating schools with discriminatory housing patterns. You would have blacks-only schools, and ultimately this would lead to a more controversial thing called busing, but I think it's coming up in a minute. So let's talk about the Klan. The movie Birth of a Nation was viewed in the White House by Woodrow Wilson. This was a movie that was about the Klan, and Wilson was a notorious racist. By 1930, there were more than 1 million members of the Ku Klux Klan, many of them outside the South, especially in the North. And it would probably surprise you to say Indiana is a big Klan city. Missouri, big Klan city. There are also rumors of presidents being inducted into the Klan in the White House, as the case was with Warren G. Harding. Harding was one of the worst presidents outside of maybe James Monroe. Not Monroe. Maybe it is Monroe. Yeah, I think it's Monroe. But Harding is right down there with him. Litigation strategies in school segregation. The NAACP is founded in 1909, and their goal was to use the court system as a pathway to attack discrimination and the segregation endorsed by Plessy versus Ferguson, ultimately culminating in one case, Brown versus Topeka Board of Education. The Warren Court overturned Plessy versus Ferguson, finding separate but equal unconstitutional. This was a big victory back in that time, but it led to some very upset demonstrators, especially. Brown versus Topeka Board of Education in 1955, known as Brown 2, allowed for individual lower court judges and school districts to design and implement desegregation plans with deliberate speed. Now, just because separate but equal was made unconstitutional does not mean that it happened that day. It took multiple years for desegregation to actually happen. And in 1957, in the Little Rock Nine, 9 African American students tried to go to Central High School in Little Rock, but the governor, that might have been in Alabama. But anyway, Eisenhower federalized the National Guard in Arkansas and ordered them to desegregate that school to allow those people to go to class inside of that house. Now, this began the Civil Rights era. The civil rights era was a grassroots mobilization effort uh, known for its peaceful protests led by the leaders like Rosa Parks, Martin Luther King Jr. There are others, the bus boycott in particular. Um, Martin Luther King Jr. writing from the Birmingham jail. We might actually read that together one day. Rosa Parks refusing to give up her seat on the bus. The Freedom Riders in 1961, and the Andy Pettis Bridge in Birmingham, or is it in Montgomery? It's in Montgomery. Um, the bus in the picture that you see there was actually firebombed. Um, the Klan forced that bus off the road and they firebombed it. Uh, it was a very bad time in America when this group of individuals were being constantly assaulted, constantly um, told they were less than, constantly told that they were less than to the rest of America. In Birmingham, this is the Bull Connor riot. The police and fire department turned on fire hoses. There were police dogs that were sticked on the crowd. Bull Connor was the sheriff, or he was the police chief. Either way, he was the guy in charge of the police in Birmingham in 1963, and was essentially trying to put down any type of protests that were coming out of these men and women. There were church bombings. They killed children in Sunday school. Bricks through windows, pipe bombs, fire bombs, the Klan intimidation, the police intimidation. It was a hard time to be. Now, following the Kennedy assassination, we end up with the 1964 Civil Rights Act. And we talked about the Civil Rights Act. Or no, we didn't. I talked about that in my other class. The 1964 Act, it's Title II, forbids discrimination by race, color, religion, or national origin in public accommodations, including hotels, restaurants, gas stations, movie theaters, and sports stadiums. It took 74 days to overcome a filibuster in the United States Senate in order to pass the 1964 Civil Rights Act. Lester Maddox ended up being the governor of Georgia in '66. Owner of the Pickwick restaurant closed his restaurant instead of complying with the '64 Civil Rights Act. And he's actually signing a baseball bat in that photo. It's either a baseball bat or it's a piece of wood. I can't remember which it was. Axe handle. It's an axe handle is what it was. He would use an axe handle with no axe on it to actually beat African Americans out of his restaurant. And that was his call to fame, was signing axe handles in the state of Georgia. It's a horrible image, but resonated. Uh, Selma, Alabama, 1965. This is where John Lewis was attacked on the Pettus Bridge. Jim Clark was the one that all they wanted to do was march from Selma to Montgomery. And when they crossed, they were told that if they crossed the Adam Pettus Bridge, they would be met on the other side with force. And I believe Hosea Williams was killed uh, during that march. And Sheriff Jim Clark was the one that laid down all the threats to actually stop the march from happening. Leading up to the 1965 Civil Voting Rights Act, this legislation facilitated the participation of African Americans through voting and campaigning for elective offices. There were more Voting Rights Acts that would further increase voting rights in 1970, 75, and 82. Not the same as the Voting Rights Act that we're seeing now, but a lot of the same effect from the Voting Rights Act, especially in Georgia, to actually stopping minority voters from voting. Now, the 1968 Civil Rights Act took aim at housing and eliminated discrimination in the housing market, from rentals to mortgage lending decisions, and segregated communities had begun to disappear. Uh, in other words, public housing generally housed exclusively African Americans. And then there was a white flight that happened during the 50s and 60s, or actually during the 40s, 50s, and 60s, following World War II, where whites fled to the suburbs and Negroes got left, or African Americans, I shouldn't say Negroes, African Americans were left behind to actually stay in what was known as ghettos. Could I have said that any worse than that? The ghettos, essentially, where there was no assistance, no rental assistance, no federal assistance. The houses were dingy and dark, and just bad living conditions all around. Um, but these communities began to disappear, and federal money began to flow into these places, allowing them to be somewhat improved. Although, to some degree, in public housing, you still have this problem, but it's not necessarily a race problem anymore. Now it's just a rich versus poor problem. Um, Let me look at this case real quick. Mendez versus Westminster. There we go. All right, so basically, in Mendez versus Westminster College of Orange County, the Ninth Circuit under Paul J. McCormick, uh, Hispanics were being sent to remedial schools and not allowed to stay inside of regular public schools with other Hispanic students. And the federal judge in this case said basically stop that. Um, that they were to be stop discriminating against these guys. There's no reason for them to go to a separate school. The federal department deportation. There was a deportation movement of Hispanics from 1953 to 1958 that targeted Texas, Arizona, and California, essentially sending them back to where they came from, which is either Mexico or Venezuela or wherever they went to. Um, Cesar Chavez represented it was a civil worker. I don't want to say something that's wrong here. So he was a labor leader. I know that. Um, okay, the United Farm Workers Labor Union. He created the United Farm Workers Labor. Well, he organized these individuals and became the face of labor unions in the United States and lobbied for the right to work for Hispanics. Um, there are still immigration issues, state law enforcement participation in deportations. A lot of southern states, Arizona, Utah, Indiana, Alabama, and Georgia, they all participate in some way or another with ICE. And that's at the order of the government, state government in Georgia especially, uh, working with the federal agency to deport what they consider to be illegals uh, out of the state borders. This has led to more modern uh, busing efforts, sanctuary cities, and sanctuary cities are just simply cities that refuse to comply with um, or refuse to comply with the federal government and to keep a local problem local, meaning they're not harboring illegals necessarily, but they're not cooperating with the federal government to aid in their their deportation either. Um, they just used local resources to help house them and to help make them legal. Um, let's see. And they basically are trying to keep the legal status away from the federal government unless the people are under investigation of a serious crime, such as murder, rape, or some kind of theft, or anything like that. As long as you haven't committed a crime, the city will try to help you. Now, Asian Americans, this is an interesting group, especially now. Many Chinese Americans were forced into difficult, low paying, dangerous jobs, especially the railroads. The Transcontinental Railroad in the 1860s and 70s, especially, um, they were the ones that handled the dynamite, handled hundreds of thousands of Chinese nationals and immigrants were killed building that railroad. Just a historical note. More than once, Congress banned further Chinese immigration. There's even more recently with the coronavirus. There's a lot of tension between the United States and China, especially with immigration. And then in Gonglong versus Rice in 1927, the Supreme Court ruled on behalf of Mississippi, forcing Chinese Americans into segregated schools for African Americans. Um, Basically, this was the desegregation of schools again. Chinese Americans were held on the same plane as African Americans and allowed to integrate into the same schools as African Americans were. And then one of the most infamous policies of FDR's term in World War II was actually the internment camps in Arizona for Japanese Americans during World War II, especially after Pearl Harbor. And women's civil rights. Prior to the 1850s, women had begun to meet publicly in grassroots efforts to gain the right to vote. In 1848, Susan B. Anthony and Elizabeth Cady Stanton founded the Western National Women's Suffrage Association. Some territories and states would grant suffrage to women before the 19th Amendment, um, and women will ultimately gain their suffrage in the 19th Amendment. That does not mean that all of women's civil rights were granted at once. Again, they now have the right to vote, the right to actually impact their world, which was 150 years in the making, by the way. But um, still, to this day, there are still things that women are especially being knocked for, like 60 cents to the dollar for every male salary, there's a woman's salary, et cetera, et cetera. We feel a way to go with that as well. In Hoyt versus Florida, the Supreme Court upheld a state law that excluded women from jury duty unless they request to serve. Um, so I feel pretty certain that that has been um, reversed by now. The Equal Rights Amendment fails to gain enough state support to be added to the United States Constitution. As far as I know, that's still an open question of whether or not the Equal Rights Amendment would actually be added to the Constitution. Um, I feel like that's something that it's just kind of stalled there. I just said something about equal pay for equal work. It's not. It's. There's been multiple studies performed that show that women make less than men for ridiculous reasons. And then of course there's the Me Too movement. Um, Women for far too long have suffered anything from locker room talk to unwanted sexual advances from men to not getting jobs because they wouldn't have a sexual response to a man or just whatever the case is. There's entirely too much of it going around, and the Me Too movement is just a partial response to probably what should happen. We still apologize entirely too often for men and their disgusting behavior towards women. There should never be a case where the words, well, she was asking for it, are uttered by anyone. A woman should be able to dress in and to do whatever the hell she wants to, whenever the hell she wants to, with whoever the hell she wants to, just like most men can. Period. Now, the LGBTQ plus movement, prior to 1962, all 50 states had made same-sex acts illegal. Um, in 1969, the Stonewall riots took place. Um, Gay bars in New York City had been raided repeatedly in New York City, and it led to 6 total days of protests and violent clashes with law enforcement outside of that bar in New York City in 1969, and it started the catalyst for those riots in 1969. Lawrence v. Texas uh, said that so again, at this point, many states had on the books some kind of criminal penalty for those that engaged in same sexual acts. Okay, Lawrence v. Texas ruled that most sanctions of criminal punishment for consensual adult, non-procreative sexual activity were unconstitutional. The Matthew Shepard and James Ware Jr. Hate Crimes Prevention Act of 2009. This was make sure I'm finding the right one. It passed on October 22nd, 2009. Was a response to the murders of Matthew Shepard and James Ware Jr., both in 1998. Expanded in 1969 hate crimes law um, to cover uh, those crimes that are motivated by um, same-sex issues as well. It required the FBI to start tracking hate crimes as well. Um, and then Obergefell versus Hodges. Obergefell was gay marriage. Gay marriage was made illegal in the United States, overruling a long-held federalism authority that states could actually um, mandate marriages by themselves. This court case ruled that states would now have to start recognizing uh, licenses and gay marriages in their states. And then Bostock versus Clayton County, I don't remember about this one at all. Title 7, okay. Oh, okay. So this is says that Title 7 of the Civil Rights Act of 1964 protects employees against discrimination because they are gay or transgender. Uh, that simply like what it says. you cannot be fired because you're gay uh, or transgender. Uh, no, the normal laws of employment um, apply to those that are gay and transgender as well. So it's good. I didn't know that one. Um, or I don't remember that one specifically. And then the United States military repealed its ban on transgender service members in January 2021. That ban went into place during the Trump administration. It's it, essentially through a tweet, which isn't how it works, but it did end up going through the official channels as well. And so ultimately repealed by the Biden administration in January 2021. Now, the elderly often face discrimination in hiring and promotion practices. The older you are, the harder it is to get a job, the harder it is to get a job, and also harder to get promoted. Um, the Older Americans Act of 1965 for health issues. Let's see. Established the Administration on Aging. Um, it This administration gives the federal government the ability to actually monitor elder rights, to dispense grants to programs that help elderly, to help the elderly and their caregivers. The Elders Legislation of 2010 was a crackdown on elder abuse, especially in nursing homes, and the Elder Abuse Prevention and Prosecution Act of 2017 tasked the FBI with collecting data and tracking data, especially on elder abuse, in order to form a report that would better monitor that situation inside the government. Now, to fellow Americans, Buck versus Bell. I do not remember Buck versus Bell either. I should. There was a state statute that compelled a compulsory, oh wow, compulsory sterilization of the unfit, including the intellectually disabled, for the protection and health of the state. Um, so this was not explicitly overturned, but this basically said that sterilization of the disabled was legal, basically, and until the Rehabilitation Act of 1973, which started to lose protection of those rights. So the Rehabilitation Act of 1973, or the Rehab Act, prohibited discrimination on the basis of disability in programs conducted by federal agencies, in programs receiving federal financial assistance, in federal employment, and in the employment practices of contractors under the federal government. Education for All Handicapped Children Act of 1975. I'll have to look that one up real quick. Um, so this is the beginning of the IEP program. If you have a child at all or if you have a brother or sister with special needs, or they're going into teaching and you're going into special education, you're going to hear about IEPs. This is a federal requirement that schools are required to evaluate a child's special needs, develop an individualized education program for the child, involve the child's parents, and educate the handicapped child along with non-handicapped children as much as possible. So basically, this is just equality under the law for those uh, handicapped. Then the ADA, the Americans with Disabilities Act, 1990, which sets forth that uh, disabled Americans cannot be discriminated against uh, under the federal law, and that states must comply with certain burdens, especially in terms of employment. There's also an undue burden clause where if the job in question can show a reasonable exception for them under the law, then they can actually ignore uh, pieces of this act. ADA. Amendments Act. I've never heard of the Amendments Act, surprisingly. Um, okay, so the Act emphasized that the definition of disability should be construed in favor of broad coverage of individuals to the maximum extent permitted by the terms of the ADA and shall generally not require extensive analysis. So essentially, it kind of smoothed the way a little bit to determine disability, and by smoothing the way, what you're essentially doing is allowing those that need those services, especially disability services, to get those services without undue burden to themselves. That's essentially what that does. And that's it for civil rights, everybody. I will see you next time.